Alright, deeds. Chapter 9. Essential matters to learn from this chapter of the deeds is a contract by which the property owner called the grantor transfers his or her property to another called the grantee. The grantor can transfer more rights and more than he or cannot transfer more rights than he or she has. These are classified as type of warrant. Grantors provide three main classifications: general warranty, special limited warranty, quitclaim. In a general warranty deed, the grantor assumes that his title can convey property will forever. The defendant of the grantee's right will give the grantee the strongest assurance for the ownership. In special limited warranty deed, the grantor warranties till the period of his ownership, but not more than any time prior to the ownership. Grantor may or may not assure the buyer he has the title, whether he has encumbrance over the property. Deeds for the trustees, sheriffs, administrative referees, and bankruptcy are in category may contain life or no guarantees of ownership. Quitclaim deed offers no warranty. The guarantee provides no assurance of the ownership when the ownership and interest for the grantor had, if any, transferred. A quitclaim deed often used to remove a cloud on title. To be valid, deed must include signature of the grantor, which must be legally competent with the name of the grantee. Description of the property considered must be stated, even if token amount, and the deed must contain the word of conveyance, interest being conveyed, and must be delivered to the grantee who accepts it. Deed has 5 parts: premises, name of the party's consideration, property description, habitum, or to have and to hold, cause, the limits to the estate, granted testimonium, warranties, if any, execution, signature, grantee, grantor, date and seal, acknowledgement, notarization required for recording. Deed may require for the county courthouse. Recording is not a requirement for the deed to be valid. Record gives the construction notice. Record gives constructive notice. Notice to the world of an existence of the deed, whether it does not assure of the deed's validity. The deed must acknowledge to be recorded means the signature of the grantor must be notarized. If the grantor fails to do the deed, then an unscrupulous seller can sell the property again to sell to someone else. If the second buyer bought in good faith and recorded his deed first, courts will award the second buyer the ownership. Sellers often move away from refuse to honor the warranty, so no matter what the type of the deed, it's important that qualified party conduct a title search to be certain that the seller, in fact, owner of the property and can convey the title. Lenders almost always require title insurance or real estate loan. An equity holder can also purchase type of insurance before issuing a type of insurance. A lender will be qualified party, perform a title search, further assurance buyer of good title. Alienation is the term meaning the transfer of property. It can involuntary act of the owner, as would be the need to get a mortgage loan or sale. Involuntary alienation occurs when the ownership of the transfer is demanded by someone else, such as a foreclosure convention. A land contract is also called a contract of deed. Installment land sale contract does not provide a deed at closing. The seller finance transaction without seller providing a deed at closing, often use the sale of a low down payment of most restored property. This type of the contract transfer of the deed after the buyer makes final payments. Typically, after many of the years, the installment payment makes it easier for the lender to continue ownership if the buyer defaults in payments. To transfer the interest real estate during lifetime, the owner grantor surrenders a deed of conveyance to another grantee. The deed of conveyance, or simply called a deed, is covered by the statute of frauds. Consequently, most writing to be enforceable, deeds are contracts no more than they are not title papers, similar to the official documents you get with a state showing that you are the owner in particular or of a particular car. Deeds are not guaranteed or backed up by any government, and any of the deed transfers property right, but those rights are only as good as the public records show that they are. Therefore, the deed should be recorded to give the public constructive notice of the existence, and the document recorded in public records must acknowledge. For most of us, that means it must be notarized. Notarization is done in notary public, someone who is licensed by the state to be a witness to an authenticate of signatures. In some counties, a few public officials, major county manager, aldermen, etc., may also authorize to acknowledge documents. The only guarantee provided by recording entity, usually county government, is recorded document is true copy of the original. There is no governmental guarantee of contents of the document. Types of deeds are classified in 3 principal types: base warranty, the provided for the grantor, grantee, general warranty, special limited warranty, and quitclaim. or any of these three types will convey whatever ownership of the grantor has in his property. The general warranty deed contains assurance by the guarantor, one, that the title of the property and the power to convey is covenant is seen. This title is good against claims by others as covenant quiet enjoyment. This property is free for the encumbrance except for the specified covenant against encumbrances. For this, they will perform whatever is necessary to make a good title good, covenant of further assurance. 5. He will forever defend the rights of the grantee of the covenant of the warranty. Of cover the guarantee warranty deed is best type of the deed of the grantee to receive. The deed contains some but all, not all. Covenant of the warranty is a special or limited warranty. Special warranty deed typically contains assurance only against the claims may have originated by the grantor held title. It does not protect against claims originated previously. Bargain and sales deeds contain no warranties, only assurance if the grantor has an interest in the property. The grantor need not to state precisely what is interest or whatever property is encumbered. It's up to the grantee to ascertain prior to closing grantor's interest in the property. There are many other types of deed, including trustee's deed, the use for the transfer of property from a trust. Referee's deed is in a foreclosure, sheriff's deed, and administrative deed. Most of these used to the person must transfer the title to someone else's property. In this situation, the authorized transfer does not wish to personally warranty title from all claims, so the deed contains a limited warrant. Most of it grouped into the type of special warranty deeds. In contrast, a quit claim decides to carry no warranties whatsoever. The grantor gives up all his rights of the property without even implying that he or she ever had such rights. Such grantor may be possessed of the property is a fee simple and absolute. The quit claim deed serves to transfer complete ownership. However, the grantor owns nothing. This is actually what the grantee received from the quit claim deed. Quit claim deeds is usually used to clear up the imperfection in the title called the cloud in the title. Cloud on the title is also called the title defect, and in circumstances where the public records are not perfectly clear about one who owns the right to a certain property. For example, Elliot Warren wants to buy Sally Smith's real estate. The public record shows Sally, along with their brothers Melvin and Paul, inherited the property from the father sometime long ago. Sally insists that she is the sole owner, and the executor deeds names only Sally as the grantee from the estate. So according to the records, the cloud is that there is nothing to show Melvin and Paul ever gave up the rights to inherit a share of the real estate. What actually happened is that when the father died, the three siblings agreed that Sally would get the house and Sally would give up her share of the father's stock and bonds, but executor failed to quit claim deed for the house from each of the brothers to Sally, and now Sally must get and record quit claim deed from them to clear the title. Deed requirements. Following elements must be present in the deed for it is considered valid. Legal, competent grantor, designated grantee, consideration even though only a token amount is shown, words of conveyance, interest being conveyed, a description of property, grantor's proper signature, delivery of the deed, and acceptance. Parts of the deed. Traditionally, deeds have 5 parts. Premises give the name of the practice, explanatory facts, words of conveyance, consideration, legal description of the property. Habitum is to have and to hold clause that may be described limit of the quantity of the estate being granted, such as to have and to hold forever or to have and to hold for life. Testimonium contains warranties, if any. Execution contains dates, signatures, and seals of applicable. Acknowledgement contains attestation by the public officer, usually a notary public, as the genuineness of the grantor's signature. Although acknowledgement is not required for the transfer, the title is usually a requirement for the deed to be recorded. Figure 9.1 and 9.2 identify the relevant parts of warranty deed, quit claim deed. Note that the quit claim contains nothing that could technically be called testimonium. This is because the quit claim contains no warranty. The grantee receives whatever interest the grantor may have in the property, but the nature of the interest usually is not stated. So if the grantor will defend against no claim but his own, the document itself is adequate evidence against him. Consequently, no warranty is included. Execution of the deed. To be considered valid, contract with the deed must be signed, grantor delivered with a grantee with the delivered escrow. See below. Occasionally problems arise with the understanding when an undelivered deed is found with the grantor's home after his death. Grantee name may claim ownership, but since the grantor never delivered the deed, the courts will not agree that the transfer was intended. The requirement of the delivery of the deed generally is considered very literally. That is, the grantee actually must have to come in physical possession of the document in order for the title to be considered transferred to her. Grantee may arrange for her agent to accept delivery for her. Common form of such delivery is delivery escrow. In this situation, the grantor delivers the deed to the trustee, but the escrow agent who holds it pending completion of some required action. Grantee such payment in full, but not given the payment of all the part price. The delivery is considered that it has occurred as soon as the escrow agent trustee received the deed. So, title transfer title, because the grantor had no deed in her possession, she will have difficulty disposing of the title until she fulfills necessary requirements to get deed released to her by agent. Alienation transfer of real property is called alienation. Voluntary alienation occurs when the transfer is not forced, when the property is sold, given as a gift, used to provide trustee, lender to secure the mortgage. Involuntary alienation occurs when the transfer is forced, foreclosure, condemnation, or when real estate is sheets to the state. Contract of the deed. In the contract of the deed, the seller finances the sale but does not transfer the title until the final payment is made. The plan is frequently used to sell resort property. The agreement may also be called installment sale contract or land contract. And that was Chapter 9. Chapter 10, Leases and Property Management.